Okay, colleagues, for the second hour, we have before us representatives of the Quebec Community Groups Network, or QCGN, a group representing the Quebec's English-speaking community. I want to welcome, before welcoming our guest, I want to welcome our colleague, Senator Marty Deacon, who will be here for the second hour. So we are pleased to welcome Ms. Eva Ludvig, President, the Honorable Joan Fraser, board member and former senator that we're so happy to meet again, and of course Marion Sandilands, she's counsel. Welcome everyone, and thank you for being with us. Ms. Ludvig, allow me to congratulate you on your recent appointment to the presidency of QCGN, and without further comments, the floor is yours.
Thank you. Good afternoon, Senators Cormier, Poirier, and honorable members of the committee. I'm Eva Ludvig, President of the Quebec Communities Group Network, QCGN, and appearing with me this evening, as was mentioned, is my fellow board member, the Honorable Joan Fraser, and our legal counsel, Marion Sandilands. The QCGN is pleased to be before you today to provide testimony on C-13 during your pre-study of the legislation. We have submitted a brief to this committee that covers C-13 in its entirety, but understand that today's meeting is focused on the use of French in federally regulated Private Business Act. So we will confine our comments on that part of C-13 and look forward to coming back to discuss the bill's proposed amendments to the Official Languages Act. We begin by noting that this committee's significant study on modernizing the Official Languages Act, conducted between 2017 and 2019, brought Canada's two official language communities together, arriving at a consensus on how to move forward on this major legislative project, a decade in the making. C-13 is not the legislation that we asked for or agreed to. Indeed, we assess C-13 as a fundamental shift in the Government of Canada's approach to the country's official languages and an abandonment of half a century of official language policy. We urge this committee and this chamber to give Bill C-13 the careful scrutiny that such a major change requires. The government is proposing to walk away from linguistic duality from coast to coast to coast and is making major concessions to Quebec, which we believe upsets the careful constitutional balance and equality in law between English and French with unknowable interpretive effects. The use of French in federally regulated Private Businesses Act is an example of this policy shift, creating a regime for language rights for only one official language on a territorial basis for federally regulated businesses. Let us be clear, there is no evidence-based reason for this act. A 2013 Industry Canada study on language of work in federally regulated private businesses in Quebec, not subject to the Official Languages Act, concluded that, and I quote, employees of federally regulated private sector businesses in Quebec, not subject to the OLLO, seem generally able to work in French in their workplaces, end of quote. Christian Paradis, the Minister of Industry and Minister responsible for Quebec, said at the time, again I quote, there is nothing in the study that indicates the need for legislation to regulate language of work in Quebec. The government will say that the use of French in federally regulated Private Businesses Act contains protections for English-speaking workers and does not prevent enterprises from communicating with their customers in a language other than French. This is window dressing. The majority of English-speaking workers are not in fact protected, and permissions are not rights. This act abandons 1.1 million English-speaking Quebecers. How could the government of Canada, we ask ourselves, create new language rights for French only, as if the members of our minority community do not work for or communicate with federally regulated businesses? How will it explain to English-speaking Quebecers that they have fewer language rights under federal legislation than Francophone citizens? Furthermore, the new act would offer federally regulated enterprises a choice between being subject to Quebec's Charter of the Language, Bill 101, and now Bill 96, and federal law. This in an area of federal jurisdiction. It is important to bear in mind that now that Bill 96 has passed, the entire Charter of the French language is subject to both the notwithstanding clause of the Canadian Charter of Rights and Freedoms and the even more sweeping notwithstanding clause of the Quebec Charter of Human Rights and Freedoms. This extraordinary choice to abide by federal law or to enter a charter-free zone of provincial law is being offered only to companies operating in Quebec. We believe this has major constitutional implications. We hope the Senate will study it not only through the lens of language policy, but also with an eye to the legal and constitutional implications. I now turn it over to Senator Fraser.
Oh, you're on mute, Senator Fraser, please. Yes. We want to make sure to hear you. Thank you.
I'm sorry. Ça ne ressemble pas à mon ordinateur à la maison. Bonsoir tout le monde, Monsieur le Président, très cher sénateur. C'est à mon tour, je voudrais vous remercier de nous accueillir. Et je note aussi que depuis quelques semaines, j'ai eu l'occasion de parler avec plusieurs d'entre vous, ainsi qu'avec certains de vos collègues, au sujet de ce projet de loi. Et j'ai vraiment apprécié que vous me consacriez un peu de temps pour en discuter. Et aussi, j'ai profité de vos observations à ce sujet-là. These are extraordinary times for Canada's official languages. Unnecessary conflicts are resurfacing that we had worked long and hard and together to move past. I wonder how strange the linguistic rancor of recent years must sound in the ears of our young people who are so comfortable with and welcoming of all manner of diversity. These are young people for whom speaking more than one language is a virtue. They are a generation that sees other languages not as a threat, but as an opportunity. This projet de loi, the use of French in federally regulated Private Businesses Act, comes at the end of a long line of private members' bills to apply the Charter of the French language to these enterprises in Quebec. The argument for those bills was that a mischief existed in the law because those businesses were subject to neither the Official Languages Act nor the Charter of the French language. They existed in a linguistic no man's land. And we agreed that they had to be brought into and made subject to language laws. So, during this committee's modernization study, the QCGN and the FCFA both recommended that federally regulated businesses be subject to the Official Languages Act. And we were pleased to see that the committee partially took up our recommendation. In 2019, you recommended that the OLLO communication and services obligations be extended to federally regulated private carriers. At the time, the government indicated that the idea was interesting but impractical, given the costs involved. Times change. This committee also had the great foresight to request independent analysis of the financial cost of C-13 from the Parliamentary Budget Officer, whom you've just had with you, and his recent report, as well as his testimony this evening, were most illuminating. Là, je vais m'arrêter et on est prête. C'est une délégation féminine, hein? On est prêt à répondre à vos questions.
Très bien. Thank you very much for your comments and thank you for being here again. So, questions and answers. 5 minutes each for the questions and the answers. So we'll start with the Vice Chair of the committee, Sénatrice Poirier. It will be followed by Sénatrice Seidman.
Merci, Monsieur le Président. Thank you both for being with us today. I have a couple of questions. My first question is on the use of French and Federally Regulated Private Business Act. It will give the federally regulated private businesses the choice of which linguistic jurisdictions it operates under, which is provincial or federal. And in your brief, you state it sets a dangerous precedent. Could you elaborate on the dangerous precedent it would set, and is the dangerous precedent limited to linguistic minority communities or broader?
So, who would like to answer this question?
I can answer that.
Okay, go ahead, Madame.
Okay. Up until now, the Charter of the French language was not applicable to any federally regulated enterprise. It is really was in provincial domain. Now we are taking federal activities and allowing them to be regulated under provincial legislation. And that is unprecedented in the language field.
Could I add something to that?
Of course.
Yes,
Yeah.
please do.
Because Senator Poirier said, does this precedent apply only to linguistic matters?
Or broader.
I'm not a lawyer, but I'm pretty sure that it could have broader implications and that it could have implications beyond Quebec should any other provincial government wish to set up a regime where its laws and regulations would apply to federally regulated enterprises. I think a federal government might have some difficulty refusing such a provincial initiative, given the precedent that is being set with this bill. And given that the Charter of the French language now is covered by the notwithstanding clause, you can see implication upon implication arising out of this, I think.
Okay, thank you. Do I have a little bit of time left? Yes. Okay, the use of the French and Federally Regulated Private Business Act also stipulates that 2 years after its coming into force, regions with a strong Francophone presence will also be subject to this law. In your opinion, is the government not limiting linguistic rights in the country to Francophones in Quebec and certain regions with strong Francophone presence? And will these regions with a strong Francophone presence be the same as significant demand from the Part 4 of the Act?
Well, these are good, very good questions to which obviously we don't have the answer, but it does open the door to all kinds of new limitations to either Francophone communities or to, obviously, as we say, the English-speaking community. And this is where you start having difficulty when you start creating new regulations, new laws that are not clear as to whether they're federal, provincial, and I think that it could lead to difficulties, and we'll have to see how that works out.
Okay. Senator Fraser, did you have anything to add?
I don't think so.
Okay. Thank you.
Thank you, Senator Poirier. Senator Seidman, the floor is yours.
Thank you, Chair. And nice to see you, Ms. Ludvig, and former colleague, Senator Fraser, especially nice. I'd like to ask two questions that hopefully the two of you will decide who will reply. The first one has to do with the move from symmetry to asymmetry and why this is a problem. And the second one is that you point out that federal government seems to be backing away from protecting its constitutional powers in terms of federally regulated businesses. And I'd like you to explain more that issue. Thank you.
Well, up until now, the Official Languages Act has been equal for both official language communities. It was to create equality. It was actually designed over 50 years ago to make French equal to English and to protect the both minority language communities. Now we are saying that, and I have to tell you that that doesn't mean that it was the same treatment, the needs were different. There was no question that the needs of the Francophone communities outside Quebec were dealt with according to their own needs, and the same with the English-speaking community and their environment and their own social and political economic needs were taken into consideration. And this was very possible under the Official Languages Act, under the notion of equal or equality. Now we are putting in a notion into the title of the act, the Official Languages Act, substantive equality. What we are doing is we're coding substantive equality. And how will that be interpreted by courts? Certainly very different from having equality. It becomes, somebody becomes unequal in this, and that's the English-speaking community.
Thank you. Perhaps Senator Fraser, if you might explain, help us understand more the federal government backing away from protecting its constitutional powers in the federally regulated businesses restrictions.
Well, as Eva said, and I will perhaps note, because she's too modest to do so, that Eva Ludvig knows this subject inside out and backwards. She worked for 20 years with the Office of the Official Languages Commissioner in Quebec. It seems to me that when in an area of federal jurisdiction, the federal government says, oh, well, you don't have to obey our law if you don't want to. You can obey provincial law instead, that you are really setting up all kinds of jurisdictional gray zones. I can imagine, for example, comparable confusion arising perhaps one day over environmental laws, or, you know, any number of things, not to mention linguistic regimes in provinces other than Quebec, where a provincial government one day may not be sympathetic to the concept of official languages from coast to coast to coast in Canada. The federal government has jurisdictions, and in my view, it has a responsibility to exercise its responsibility in those jurisdictions. That's why we find it so worrisome that not only in terms of federally regulated private businesses, but more broadly, the government is backing away from symmetry, which is part and parcel of the fabric of this country. It's part of the Constitution of Canada. It's been part of the Official Languages Act 50 years, and it's been something that we have built modern Canada upon. And suddenly to say, well, no, it doesn't matter, is, I think, not a good harbinger for the future.
Thank you very much.
Thank you, Senator Seidman. Madame la Sénatrice Gagné, the floor is yours.
Pardon, j'étais prise dans mon couvre-visage. Alors, bienvenue, Madame Ludvig et notre chère collègue, l'honorable Joan Fraser. Fait plaisir de vous revoir. This is a question, having read your memoir and also hearing your answers. Are you saying that the proposed new use of French in federally regulated private businesses act grants rights to francophone that it does not grant to anglophones, and that it poses a risk to the rights of Quebec's English-speaking communities recognized under the Official Languages Act and the Canadian Charter of Rights and Freedom?
Yes, that's exactly what we're saying.
And could it be subject to a legal challenge?
I'm not a lawyer, but I would imagine, you know what, I will turn it over to our counsel, Marion.
Thank you. I am a lawyer, but I'm going to decline to speculate on potential legal challenges to this law at this time.
Okay.
Okay, I'm not a lawyer, but Senator
Yeah.
Gagne, the elements that refer to the Charter of the French language are covered in large measure, not entirely, but in large measure, by the notwithstanding clause in the Constitution of Canada. And the whole thing is exempt from the Quebec Charter of Freedoms. So legal challenges are already being planned for parts of Bill 96, but they're having to be devised, shall we say, very creatively, and who knows how it'll turn out.
Thank you. Last week, the province of Quebec corresponded with the members of Parliament in the other place on Bill C-13. Would you mind providing a commentary on their proposal and the importance and value to maintain the reference to the English-speaking minority within the Official Languages Act?
Well, the QCGN has not received these recommendations, so we cannot comment upon them specifically. But we did study Quebec's position paper of February 2021. And from that paper, it was clear that Quebec was asking for a very asymmetric framework in the OLA to focus on the protection and promotion of French only, and to cease to recognize the English-speaking minority in Quebec as a minority. Then C-13 introduced that asymmetry, although it continues to recognize the English-speaking community as a minority. And that's questionable as how that will work out. Quebec also wanted the Official Languages Act to treat Quebec differently, which C-13 does. And Quebec also advocated for subjecting federally regulated private businesses to the Charter of the French language, which C-13 creates this option, and which, as Senator Fraser has just explained, is worrisome, not covered now under the notwithstanding clause. What does that mean for the federal activities in the province?
Thank you. Thank you for your answers, and thank you, Sénatrice Gagné. Sénateur Dagenet, la parole est à vous.
Merci, Monsieur le Président. Alors, je veux saluer ma collègue, Mme Fraser, content de vous revoir, et j'ai une petite question pour vous. La ministre québécoise de la francophonie, Mme Sonia Lebel, a fait part la semaine dernière de certaines attentes face au projet de loi C-13, et je résume rapidement quelques points. Elle estime que la loi C-13 n'a pas à faire la promotion de l'anglais seulement qu'au Québec, donc ça doit se faire aussi dans les autres provinces. Elle dit aussi que dans ses communications au Québec, la loi devrait obliger le gouvernement fédéral à donner plus d'importance au français qu'à l'anglais dans ses communications bilingues. Alors, j'aimerais savoir ce que vous en pensez.
Je pense que vous pouvez deviner. Hein?
Oui, un peu.
Écoutez, comme nous venons de le dire, nous trouvons qu'il est vraiment primordial de garder la symétrie dans le texte de la loi pour ce qui est du statut légal des deux langues. C'est tout le contraire que le Québec fait avec sa propre législation et tout le contraire de ce que le Québec demande au gouvernement fédéral en ce moment. Nous, on trouve que je me répète, mais on trouve que la symétrie dans la politique nationale linguistique est d'une importance primordiale. On peut, et au Québec, on veut dire que dans une province, il y aura un régime pour tout ce qui touche à la juridiction provinciale. Au Québec, le choix a été très clair, surtout avec le projet de loi 96, que ce qui compte, c'est le français, uniquement. La place de l'anglais n'est presque pas reconnue même. On parle parfois de la possibilité d'utiliser une langue autre que le français, mais il n'y a aucune reconnaissance de l'existence même d'une minorité anglophone au Québec. Alors, il me semble que c'est une philosophie totalement à l'opposé de ce qui a toujours été la philosophie qui sous-tend la loi fédérale et qui, selon nous, devrait continuer à être le principe de base pour la loi fédérale.
Si je peux ajouter.
Oui, oui.
Okay. L'autre chose, c'est que le Québec a décidé de définir la communauté anglophone comme une communauté, comme les anglophones historiques. Ça coupe la communauté en presque la moitié et ça enlève des droits de beaucoup des anglophones qui ont été ici pendant très longtemps et qui ont besoin des services comme tous les Québécois.
Et est-ce que vous croyez à ce moment-là que le projet de loi va suffisamment hériter des groupes au point où, aussitôt qu'il va être adopté, il va faire l'objet d'une contestation judiciaire basée sur la Constitution de 1867?
Tout est possible. Une chose que je peux vous dire, c'est que ce qui m'inquiète aussi, la dualité linguistique, la langue officielle, est une valeur canadienne dont tous les Canadiens sont très fiers. Et si on passe ces 13 telles quelles, ça va diminuer, je crois, parmi les Canadiennes, leur estime, leur fierté dans la loi sur les langues officielles, dans toute la valeur canadienne de la dualité linguistique. Et j'aimerais juste demander notre conseil légal, Marianne, de nous parler.
Bonjour, je voulais juste ajouter un point au sujet des positions de Québec. Dans notre mémoire, on a raconté l'histoire de comment le consensus entre les communautés de langue officielle en situation minoritaire, il y avait un consensus qui a été formé en 2018 et 2019. Eh bien, le rapport de ce comité même reflète ce consensus. Et on voit après le consensus était établi, on voit après ça l'entrée du Québec dans la conversation, qui a changé à notre avis. Et dans notre mémoire, au paragraphe 36 à 48, on raconte comment, à notre avis, ça a changé complètement la conversation et ça a rendu à le projet de loi C32 et C13.
Merci beaucoup, mesdames. Merci, Monsieur le Président.
Merci, sénateur Dagenet. Donc, maintenant, la parole est à la sénatrice Deacon et sera suivie par la sénatrice Clément. Floor is yours.
Thank you. It's quite a job. Thank you, and glad to be here today. And thank you to our guests. This is not my wheelhouse of expertise, but I am really trying to understand this from all angles. I want to preface this that way, and with specific respect to C13. So what I'm wondering, and I saw a good chunk of it, is if you folks, tonight was divided in sort of two halves, and the PBO has left and done a presentation and report with questions. I'm curious as to our witnesses this evening, your thoughts on what you heard, because I think you were there, for the PBO and sort of the reality and the implications, or perhaps an opinion from your perspective based on that report earlier this evening.
Senator Fraser, would you?
Oh, well, I must say that we were busy preparing for this session of your meeting, so our attention to the PBO was frequently interrupted. But from what I've seen previously about his remarks, his findings, as I understand it, he's saying that great portion of the added costs for enterprises would be in regions outside Quebec, which have a significant Francophone presence. That, I would think, might lead to some political ruckuses when it comes into effect. I want to stress that we at the QCGN formally recommended that those enterprises be brought under the Official Languages Act. We believe that it is important wherever there is a reasonable number of members of a linguistic minority that those people get service in their language and to the extent possible be able to work in their language. We're not just pleading the cause only of English-speaking Quebecers. We have a long history of supporting Francophone communities outside Quebec, politically, legally. So when I say that that seems to be where the cost is going to be greatest, that is not, in my view, a reason to say those companies should not come under the Official Languages Act. But as you look ahead, you can see that perhaps there have been questions this evening about, will there be legal cases brought, that kind of thing. I think that there might be some, at least political argument advanced in some of those regions. And I would hope that this committee's work would help to defuse any such arguments ahead of time.
Thank you. I'm not sure if anyone else wished to comment or not.
Not at this time.
Okay. You had any other questions, Senator Deacon? It's all right?
No, listening and learning.
Okay. Thank you so much. Thank you. Sénatrice Clément, la parole est à vous, suivie de la sénatrice Mention.
Good evening to the witnesses, and thank you. Thank you in particular to Madam Senator. I'm new to this institution, and I now more fully realize how much work senators really, really do. And so I'm grateful to you, Madam Senator, for your work. I am a former Montréalaise, former Québécoise, now a Franco-Ontarienne. And I grew up in the days of La Loi 101 with English and French family. And you can imagine the dinner conversations I had in those years. And I have to tell you, now with Bill 96, those dinner conversations in true Québécois fashion are also heated in my French and English families. So I'm trying to sort out C-13 in the context of this Bill 96 in Quebec. You mentioned, Madam Senator, that you had good conversation with La FCFA, and you were on board in the previous iteration, and now have you communicated with La FCFA recently concerning C-13, this current version? And where would you be now compared to them? Where would things converge or diverge now with La FCFA?
I have not personally been in touch with them. I know that the QCGN has on the staff level, and I believe that our previous president, who only left us a week ago, was in touch with them, although I'm not sure about that. But I can't speak to their position. It's obvious that their principal concern is for Francophone communities elsewhere than in Quebec. And to the extent that this bill advances the interests of those communities, that would be their main focus. But I haven't been in touch with them myself. And thank you for being so welcoming.
May I add?
Yes.
Yeah. We, as mentioned in our brief that we gave to you, we have had very close relationships leading up to, and we were on the same wavelength in terms of modernizing and so on. And it's when things changed in Quebec that we started going in divergent directions, which is unfortunate.
Mm-hmm. May I follow up, Monsieur le Président?
Yes, of course. Go ahead.
Just around English-speaking Quebecers now, and whether, if you could comment on, whether this use of French in federally regulated Private Businesses Act poses a risk to their employability. Could it pose a risk to their advancement? And in fact, are they currently well represented in these businesses?
I can speak to that, having worked in the field for a long time. And what has been very evident in Quebec is federally regulated businesses, by and large, provide very good services in both language services. And there have been very few situations, as we saw with Air Canada and as we've seen in the past. And you didn't see that happening in Quebec with the services. And what now is really worrisome is the future of our young people who would want to work in federally regulated businesses, which is a good employer, and where you do find, because of the requirements often for bilingualism, and our young people are bilingual, you do find them that these are good positions for which they are qualified. And all this changes that environment. And we do have the English-speaking community, contrary to all the myths, has a higher unemployment rate and a higher poverty rate. And this is just another problem which will affect employment and possibly services to English speakers in Quebec.
Thank you.
Thank you, sénatrice. Madame la sénatrice Mention, la parole est à vous.
Merci, Monsieur le Président. Welcome to the committee, and nice to see you, Senator Fraser, and your colleagues. I just want to go back to the question that was Senatrice Clément was asking about employment and the risks. How are they impacted when they do apply for federally private businesses?
Well, when you work for any of those companies right now, you can have your HR services, your payment and training, just as on the same level as francophones, English speakers. They would both have access to all these. Now, all this is up in the air in terms of communications to employees. And then, of course, there's the question of the communications to clients and to customers. How will that be affected? Particularly since companies that will be under the Charte de la langue française will have to do a lot of work to demonstrate that an employee has to have English in order to be employed.
But I understand. I just want to go back. Sorry, I just want to go back to a comment that you just made to Senatrice Clément about the higher unemployment rate of English-speaking Quebecers in Quebec. I'm sorry, Senator Fraser.
Yes, that's okay.
Just going back to that comment.
Yes, the unemployment rates of English-speaking Quebecers is higher than for the Francophone majority in Quebec. And I don't have it at the tip of my fingers, but we could send it to you, the data on that.
But I just want to understand why it is so in Quebec. Why is it so in the federally private businesses?
I am talking about the possibility of employment. So it is important not to cut off another channel of employment since we already have a higher rate of unemployment among English speakers. And up until now, federally regulated businesses as the public service of Canada were opportunities for English-speaking bilingual young people to be hired. They had good chance of being hired because they were bilingual and they had to provide services in both French and English.
Okay.
And
Thank you.
if I may, on that point, Senatrice Motion, the proposed bill, not just if for companies that would choose to go by Bill 96, but the proposed federal legislation says that companies must provide services in French. They may provide services in English. They may require, therefore, some employees to be bilingual, but they will have to demonstrate that those employees need to be bilingual French-English, that they need to speak English as well as French. That's a hassle. It's going to be much easier for companies to say, bilingualism not only is not an asset, but we don't want to go through all the fuss of demonstrating that it's needed. So we'll provide services in English. So we don't need to hire these bilingual Anglophones.
Okay.
If you see the chaîne there.
And okay, thank you. The nuance. If I may, Monsieur le Président, I have
Yes,
another
you still have
question.
a bit of time. Yes, go ahead.
Thank you. My other question is, in the document that you provided to us, you're asking that the Charter of the French language be removed from C13. Could you explain, or could you give us, a rationale behind this? And I know it's in your document, but I want to hear it from you.
Well, we explained that the Charter of the French language invokes the notwithstanding clause. That means that then the C13 or the federally regulated businesses would actually have to also apply the charter in the same way, and and there would be no recourse to the courts. And I will turn to our counsel, who will enlighten us better on that. Marion?
Thanks. In our brief, we give a few reasons why the references to the Charter of the French language in C13, both the Official Languages Act section and the Federally Regulated Private Businesses section, are problematic. As Ms. Ludvig pointed out, one of the big ones is the presence now, after Bill 96, of the notwithstanding clause over the entire Charter of the French language. It would be the first time ever for federal legislation to explicitly recognize a provincial law that uses the notwithstanding clause in that manner. Other reasons why it seems to be a bit of an anomaly in the Official Languages Act, for example, it's the only provincial legislation that is singled out in the clause that cites the different provincial language regimes that promote English and French. Actually, the Charter of the French language is the only provincial legislation in that list. Why would the Official Languages Act single out only one piece of provincial legislation when there's actually quite a bit of other provincial legislation that promotes the French language and bilingualism in other provinces? That seems to be an anomaly. Also on Bill 96, it transforms the Charter of the French language. It's not the Charter of the French language that we had last year. The new Charter of the French language has been transformed under Bill 96, and it's not clear whether that reference in C13 really takes into account all the things that have changed in the Charter of the French language from Bill 96. So those are some of the main reasons why the QCGN has recommended that those references be removed. And I'll just end with, finally, for the Federally Regulated Private Businesses Act, there's a reference in Section 6 of that Act, and we've talked about it already, about the choice of law, the choice of the Charter of the French language or the federal law. And we've explained some additional reasons already why that's problematic from a constitutional perspective.
Thank you.
Thank
I don't know,
you.
Senator Fraser, if you wanted to add something to this.
I'm always hesitant to try and elaborate on Marion because she knows her stuff so very well. I think she made the case.
Thank you.
Thank
and that's what
you.
I wanted to hear from you. Thank you very much.
Thank you, Senator Mention. I will ask a question before the second round, just to put this on the record, and I will be quite direct in my question to you. You know, like we receive your brief, of course, which is very important, and there's a lot of content in there. And so, do you simply think that the Part 2 of Bill C-13 should be simply withdrawn from the bill, for example? And what kind of specific amendments could you just give us, today, so that we can put this on the record to understand specifically which amendments you would like to bring forward?
Well, obviously, the mention of the Charte de la langue française, that's number one. Number two, the question of only protecting the rights of one language group, the Francophone, French-speaking. We think it should be equal. English-speaking employees should have the same rights, and French-speaking employees should have the same rights. And I think our council will probably have more to add to that. Marion?
Actually, Ms. Ludvig covered the substance of our recommendations. They're recommendations 8 and 8A, which are found in Appendix B of the brief,
Yes.
which 8 says any language rights should extend to English and French speakers. So just to state the obvious, that's not an easy amendment to this act the way it is crafted. And 8A is specifically about removing the reference and the choice of being subject to the Charter of the French language, and that's in Section 6 of the Act.
Senator Fraser, do you have something to add to that?
Just a thought.
Yes.
Given that the title of the proposed legislation specifically refers to the French language,
Yes.
Some may be wondering whether it would be going against the very principle of the Act to make the changes we recommend. I don't think it would. I think that it is inherently a protection and promotion of the French language to bring these enterprises under the federal linguistic regime. And as Eva Ludvig said, in principle, it's a good thing for Quebec. I think it's vital for regions outside Quebec. But the protection and promotion of the French language, it's a noble, noble cause. It's vital to the country, but it must not be done at the expense of other minorities, in my view.
Mm-hmm. Thank you. Thank you so much. So second round, Senator Sidman, followed by Senator Dagenet and Senatrice Gagné. Senator Sidman.
Thank you, Chair. And thank you again, Ms. Ludwig and Senator Fraser, for really helping us understand the consequences, negative consequences to the English-speaking minority language community in Quebec. I think the issue about the reference to the Quebec's Charter of the French language is a critical one, and I know Senator Motion asked about that, and you expanded to some extent. I would like to go back to that because I think it really bears emphasizing. And if you have more to say about the impact of having Quebec's Charter of the French language, a provincial law referred to by name in Bill C-13, the impact of that, would it negatively affect the interpretation of recognized rights of the English-speaking community? And in fact, would it contravene Canadian Charter of Rights and Freedoms, which state that English and French have equality status and equal rights and privileges? I'd like to just give you the opportunity because it's a big ask to remove it, and you say it should be removed, and I'd like you to have the opportunity to further speak to how it might impact recognized rights and, in fact, contravene the Charter of Rights and Freedoms. And I will just add one last thing. The reason I'm emphasizing this is because a couple of days ago in the French press, there was a quotation from the Quebec Justice Minister, Julie Barrette, who said that he would like that the Canadian Charter of Rights no longer apply in Quebec. So, okay, I'm going to give you the floor and see if you have something to say about that.
Well, you know, once again, I would repeat that the Charter of the French language has invoked or will be covered or is covered now by the notwithstanding clause. So no recourse for English speakers in the courts, okay, to protect their rights, to speak for their rights in terms of being able to get service. The Charter, it's important, I think, for everyone to be aware of the changes that have come to the Charter under Bill 96. The English-speaking community has lived with and accepted Bill 101, has accepted the Charter of the French language the way it was. And the changes are substantial, aside from the notwithstanding clause. Significant changes in all, including access to justice, it touches our educational institutions. It has impact on the Indigenous community. So it's huge. And it, again, narrows the definition of what English speakers have rights, which ones. The historic Anglophones, which is a much smaller group than actual English speakers. So it's huge. And the way it stands now, it would have tremendous negative impacts on the English-speaking community.
If I could add a little something here.
Yes,
please do.
It seems to me highly possible that if this proposal to give companies the ability to choose which regime is adopted, that there will be, certainly from vocal quarters in much of Quebec, political pressure for those companies to abide by the provincial regime, to choose the provincial regime. That regime, as we have said, as Eva just said again, blocks off a good deal of the potential recourse to the courts. And let me give you one example that has been much discussed in Quebec. The Office de la Langue Française is given the power to go into businesses without a warrant and look at any documents or electronic equipment, your phone, your laptop, anything you like, to see if, in its view, the rules under Bill 101, the Charter of the French language, are being respected. It can do this, as I say, without a warrant on the basis of an anonymous complaint. If you feel yourself being pressed, perhaps by your customers, to abide by this law, it's not just that the principle of the Charter of the French language is antithetical to the fundamental philosophy of the Official Languages Act. It's that you may find yourself with real practical problems, and your recourse to the courts will be sharply diminished.
Thank you.
Thank you. Thank you, Senator Steedman. Sénateur Dagenet.
Merci, Monsieur le Président. Merci. Évidemment, ma question va être pour Mme Fraser. Évidemment, vous comme moi, là, on a été témoins de plusieurs débats sur les droits des francophones au pays, plus particulièrement au Québec. Maintenant, on est en 2022. Quelle évaluation faites-vous aujourd'hui de la diminution graduelle du français et du fait que partout, on voit dans l'immigration maintenant la façon de mettre un terme à cette érosion des groupes francophones?
Personnellement, je n'ai pas constaté une érosion du français au Québec. Il est vrai qu'il y a eu une augmentation de gens dont la langue maternelle n'est ni le français ni l'anglais. Ça, c'est le fait de l'immigration. Mais les enfants de ces gens-là seront tous francophones parce qu'ils sont dirigés dans les écoles françaises. Alors, si vous voulez, s'il y a un problème, c'est un problème, à mon avis, temporaire. Nous connaissons tous des gens dont les parents sont nés dans une autre langue que le français ou l'anglais. Mais les enfants, eux, sont francophones. Ça, j'en connais un paquet. Et ce sera le cas. Donc, s'il y a un problème, à mon avis, c'est un problème de transition, si vous voulez.
Et ne pensez-vous pas que le projet de loi C13 sur les langues officielles a une espèce d'essence politique et c'est de répondre à la diminution du poids des francophones au pays, d'après vous?
Le poids des francophones ne diminue pas au Québec.
Et au pays?
Le poids des francophones au pays, oui, ça inquiète tout le monde et il faut tout faire pour aider ces communautés-là. Je ne suis pas sûr que la loi sur les entreprises de juridiction fédérale au Québec va beaucoup aider les communautés qui en ont un besoin désespéré. On ne les nie pas. Ils ont besoin de tout ce qu'on peut faire pour les aider, c'est sûr.
Merci beaucoup. Merci, Monsieur le Président.
Merci, sénateur Dagenet, et merci pour vos réponses, sénatrice Fraser. Madame la sénatrice Gagné, la parole est à vous.
Oui, je vois que le temps avance. Tantôt, j'ai posé une question relative à une contestation judiciaire potentielle, puis je respecte bien le fait que vous ne vouliez pas nécessairement spéculer là-dessus. Il reste que j'aimerais que vous commentiez sur le fait que le projet de loi assure quand même la viabilité institutionnelle du programme de contestation judiciaire qui avait été aboli autour des années, je pense, 2005-2006, malgré le fait que les communautés de langue officielle en situation minoritaire le jugeaient essentiel. Je suis consciente aussi que le fait qu'on réfère à la charte de langue française dans le cadre du projet de loi, qu'il y a une clause dérogatoire aussi face à la loi 96, Judith? 96. Seriez-vous quand même en mesure de commenter sur l'importance du programme de contestation judiciaire pour vos membres?
Le programme de contestation est un programme très important pour les communautés francophones et les communautés anglophones. Et c'est important de le garder. Maintenant, je vais demander à Marion si elle a quelque chose à ajouter.
Oui, merci. On a fait quelques commentaires à ce sujet dans notre mémoire. Eh bien, on a fait des recommandations là-dessus et on a deux recommandations. Premièrement, on observe que oui, le programme de contestation est mentionné maintenant dans C13. Et oui, c'est très important à notre communauté et bien les communautés en situation minoritaire francophone. Mais deux recommandations. Premièrement, on voit que le programme est mentionné, mais il n'est pas obligatoire. Alors, on recommande de rendre obligatoire le financement de ce programme dans la loi. Et deuxièmement, élargir la portée du financement possible dans le cadre de ce programme au-delà des causes types. Alors, quelque chose un peu plus large qu'on voit dans la libellé présentement.
Merci.
Merci beaucoup. Je vois le temps qui file. We're at the end of this very, very enlightening hour. So we want to thank you so much for your comments, for your answers, and for the importance of the work you're doing in Quebec, and for also what you're recognizing how it is important in the rest of Canada that the minorities are well protected. So sincerely, thank you so much. And we will, of course, we have your brief, so we will make sure that is taken account when we'll do our study, because as you know, we are in a pre-study process right now, and we're expecting the bill C13 as soon as possible. So thank you very much. Merci beaucoup à vous tous et à vous toutes, et merci, chers collègues, de vos questions, de vos réponses et de votre participation. Alors, la séance est levée.